Welcome to Subramani. I'm going to talk about estate planning for women. Women are choosing to remain single. Women are choosing to be in childless marriages, or men and women are choosing to be in childless marriages. Women are getting divorced and women are getting widowed. Right, so at some stage, women will have to manage their own finances. Normally, it's something which they procrastinate and they outsource. Oh, my father manages my money, my brother manages my money, husband manages my money, my son manages his money. Right, my mother, for example, has never managed her money. It was managed by my dad and then by me. I don't think even not much by my dad, but by me. So I have to live long enough to make sure that her money lasts till her end, right? So will she manage it on her own? I doubt whether she will want to do anything. But right now I can do one thing. I can put money in a fixed deposit and say, just live off it. She's 87. So that's one solution available for her. But it's not available. That simple solution may not be available if you're, say, 55 and you've been widowed and your husband has been managing your money. And suddenly now you will have to manage your money, right? So, and you don't know, maybe you're not even paying electricity bills and telephone bills. So all that will have to be learnt, right? Maybe your husband was paying, maybe it was joint money, but you didn't know how to set it up. Nothing you did. It's not rocket science, but somebody has to make an effort to learn. So let us start with the single woman. A single woman has complete ownership and control of whatever assets she has earned, and maybe whatever she has inherited from her parents or any uncle, aunt, anybody, right? So what are the key things which are required for certain things are common. Every immaterial of what is your status, you have to make a will. Whether you're a man or a woman, you have to make a will. But I'm talking here very specifically about what are the things which are required. First, will. Draft a clear will to specify the beneficiaries, parents, siblings, nephews, niece, uncle, aunt, whoever you want to go to, charity, right? Without a will, assets will be distributed as per the Succession Act or the Hindu Succession Act, or the for all the Sikhs, Jains, Buddhists, etc., or for the Muslim personal law, right? So according to that, we don't want that to happen. So please make a will. That's the most important thing. Wherever it makes sense, you put nominees, right? If you want to, if you have mutual funds, put nominees. If you have insurance, you would have definitely put the nominee. Bank accounts, you would have to put the nominee. Do that. Try giving a power of attorney, because a power of attorney, technically a power of attorney should be used only when you're alive. But if you're unable to sign for whatever reasons, then that power of attorney can come into play. Maybe you're in coma, maybe your hand is fractured, something like that, so that your money can be used for yourself when you're alive. Somebody else has to have access, right? And you may not want to make that person the second holder in your bank account. So do that. Right now there is no, you don't have to worry about estate duty, but estate duty will come in India. I do not know when. Challenges are some family disputes, saying how can she do this? So family can dispute. But if you're a single woman, I don't think you should bother too much about people fighting over your legacy, unless you want to give it to somebody specific, right? So, but be careful about that. What about married women? Married women could perhaps have something called Stridhan, which she got at her wedding. Sorry, excuse me. Right. So then there will be joint property with she holds with her husband. Now be very careful here. If I and my wife own a property jointly, I own my half, she owns her half. I'm assuming half. I can give away my half to my daughter and she can give away her half to her nephew or niece or anybody. It is possible, theoretically. It never happens in practical life. So, but it is important to understand that the joint property still means two owners, each owning half of it. So, I have to make a will giving my half to my wife. In case I die, it should belong to her. And she has to make a will saying her half will come to me, assuming both of us want to give it to each other. And then we can make a will saying wherever, in case both of us die, or then the whole thing will belong to my son or daughter or whatever. So be careful about that. Don't assume that because your wife is the second holder, it will automatically go to her. That happens only in case of savings account. It does not happen even in case of demat. It does not happen even in case of property. It definitely does not happen. In case of demat, that account will have to be closed, and my wife, suppose I die, my wife, my joint account with my wife, which is an either or survivor account, will close, and then she will have to open an account which is single name and transfer everything there. That is the law, right? You can also create a private trust, but I wouldn't suggest private trust for anybody unless the amount involved is at least 20-30 crores. A private trust I would also suggest for somebody inheriting, some son, not so much for a daughter, but for a son. If you have your money being inherited by your son, better to put it in a trust to protect it from bad marriage, right? You don't want a bad marriage for your son to lose a lot of the assets. He'll definitely lose income, but you don't want him to lose assets, so be careful about that. And as usual, for whoever, man or woman, make sure that the nominations are in place in mutual funds, etc. The nominee has not predeceased you. If the nominee predeceases you, you made your mother the nominee, but your mother is no longer there, and you're single and you don't know whom to make. You have to make somebody the nominee. So make sure that you make the same person the nominee who should get the assets, right? So do that. If the husband has a will, make sure that you coordinate and you avoid conflicts, right? So you're married and you so you make joint, if you want you can make a joint will, you can make separate wills, whatever it is, but make sure that there is no conflict, right? A wife is a class 1 heir and inherits equally with the children. Challenges would be from in-laws. If the husband dies and she makes this happens in case of early death of the husband. If the husband is 45 and dead, then the chances are that the in-laws are alive and they are trying to dictate what she should do. So she should be careful about that kind of pressure also. Divorced women have to very quickly make sure that the papers are in order, because in case of a divorce and you have the wife is walked out with the child or children and she has not filed the divorce papers with the insurance policies, chances are if she dies the money will go to her ex-husband, and that is unintentional. So in case for divorce and in case of widowhood, it is very one has to act very quickly. For example, if you are you have a life insurance policy in which your husband is the nominee, husband has died, now you have to very quickly go and change the nominee, because if you die then that whole thing will be intestate, because there is no nominee, is not mentioned in the will, because you did not make a will. It could become a mess, right? So if you have a divorce or if you are widowhood, then very quickly, as soon as you get the divorce decree or as soon as you get the death certificate, please make sure that you change the nominees also, and in case you have to make changes in the will, make those changes also, right? So you would have made your husband the nominee in the house that you own. Husband has died, now you have to make your son or your daughter, or if you don't have children, then your sibling, somebody else, but definitely not your husband, because your husband is already dead. So remember that these are small legal nuances which you should know. For example, Muslim women can bequeath only 1/3 of their estate unless heirs consent to more. This is as per the Sharia law. So you have to know all that. You should know which law is applicable to you. So I think the most important thing is, it's easy to go to Google and look for a draft, but better to go to a lawyer and make sure that the processes, for example, you have to make the will, you have to sign it, there has to be a witness, there has to be a doctor's certificate, you have to then notarize it, and then you get it registered in the court. Now you need not do the last thing if you're still in your 50s or 60s. You can do it in your 80s, saying, I'm not going to buy any more property, so now let me go and register my will. So you can do all those things. So if you're a widowed woman, you have to also look at what you're going to inherit from your in-laws side, right? So maybe you're just 40, your husband has died, your father-in-law is still there. Make sure that you're part of the will, or if you're not part of the will, you're not part of the will, but at least some of that could also come, and that you may want to just pass it on to your children, because that is not your property technically, though you have inherited it. And in that, if there is a dispute, the kids can go to court, and you want to avoid all that mess, right? So the Muslim woman will receive less as per the Sharia law. We're not getting into it, right? So first of all, yes, as usual, make a will. Direct how the estate should go to the people after you. You're inherited, what you've got, what you've got from your parents, what you've got from somebody else, what you've got from your husband, all that together, your husband and husband's parents, right? If your husband predeceases, whether they give it to you, all that should be there in the will. Obviously you will nominate all properly, and then you will, in case the amount is big, you may have to create a trust, especially if you have minor children. In case of remarriage, make sure that the nominations etc. change, or you want to give away your property to your children, take care of all that. But in case of marriage, in case of divorce, in case of widowhood, in case of remarriage, there will be need for a will with changes, right? Vulnerability to exploitation again by relatives etc. is there, so be careful. Consulting a lawyer is very useful therefore. So legal framework, succession laws are very different according to the religion. Indian succession, Hindu Succession Act, there is the Indian Succession Act for Christians and Parsis, then there is a Muslim personal law which is the Sharia law. So seek legal advice saying what is applicable to you. Documentation, maintain updated documents of your assets, your property etc. I mean, even if you want to make property papers for your fridge and television and laptop, that's fine, but definitely real estate etc. So then bank statements, insurance policies, and store them securely, wherever you want to store it, store them securely. Tax planning, right now there's no estate duty planning to be done in India, but it will come soon. Make sure that you appoint a good executor or a trustee who is interested in doing it, and please provide for a fee. Regularly update your will. I mean, this I'm saying for everybody, man, woman, Hindu, widow, whatever, divorcee, doesn't matter. Please make sure that you keep updating it. Consulting a lawyer who specializes in this is very useful. Educate yourself on property rights. Many women don't even know what they're entitled to. Make sure that if your husband has a pension, whether any lump sum is receivable from his insurance company, you need to know it, especially if you don't have anybody helping you, you don't have a advisor, financial advisor or a lawyer, then you need to know all this. Communicate intentions to family if you're comfortable, and then make a will. Estate planning empowers women to secure their legacy and protect your dependents and asset control over your hard-earned assets. Don't waste that opportunity. Thank you.